I never thought I'd have to lawyer up to keep what was rightfully mine, especially not something my family had owned for generations. But there I was, staring at a certified letter claiming that portions of my family's ranch were actually community property, belonging to the Sagebrush Estates Homeowners Association. I'd fought in Afghanistan, started a small cattle operation, and weathered 3 years of drought, but nothing had prepared me for the storm that was about to hit me head-on, a storm named Karen Thornhill. My name is Xavier Thorne, and for 5 generations, the Thorne family has owned and operated the Running T Ranch on the outskirts of what is now Cottonwood Springs, Colorado. What started as 500 acres of untamed frontier land purchased by my great-great-grandfather in 1892 had, over the years, been parceled and sold off as the town expanded, leaving us with a still respectable 120 acres of prime grazing land with mountain views. The trouble started 3 years ago when the Sagebrush Estates development broke ground adjacent to my property. The developer, Milton Prescott, was a reasonable man who understood the boundaries and even offered to buy a 10-acre parcel from me, which I declined. We shook hands. I wished him luck with his luxury mountain community. And that was that, or so I thought. Milton sold the development to Evergreen Properties before the first foundations were poured. The new owners brought in a management company, and with it came Brenda Zimmerman, the HOA president from hell. I remember the first time I met her. I was mending a fence line when a glossy white Range Rover kicked up dust on the access road and came to a stop about 20 yards away. Out stepped a woman in her mid-50s with a blonde bob so perfectly shaped it looked like it could withstand a Category 5 hurricane. Her pantsuit probably cost more than my monthly cattle feed, and the expression on her face told me she wasn't stopping by to welcome me to the neighborhood. "Mr. Thorne?" she called out, navigating the uneven ground in her impractical heels. I tipped my hat. "That's me. What can I do for you, ma'am?" "I'm Brenda Zimmerman, president of the Sagebrush Estates Homeowners Association. We need to discuss your operation here." The way she said operation made it sound like I was running a meth lab rather than a family ranch that predated her birth by several decades. "What about it?" I asked, driving the last staple into the fence post. "Our homeowners have concerns about the smell, the noise, and frankly, the unsightly view of your cattle from their premium Mountain View properties." She handed me a business card with the HOA logo embossed in gold. "We'll be sending formal notices regarding violations, but I wanted to introduce myself personally." I pocketed the card. "Ms. Zimmerman, this ranch has been here since before Colorado was a state. Your homeowners knew there was a working ranch next door when they bought their premium properties." Her smile didn't reach her eyes. "Perhaps you're not aware of the new county ordinances regarding agricultural operations in proximity to residential developments. We should get you up to speed." That was the first salvo in what would become a relentless campaign. Over the next few months, I received notices claiming my cattle were too noisy, my equipment was eyesore, and that my property was devaluing their homes. Each letter was signed by Brenda Zimmerman, HOA president, in a flowing script that somehow managed to look both elegant and threatening. I ignored them all. My property wasn't part of their development, and I wasn't subject to their rules. I had the county zoning department confirm this in writing, which I thought would end the matter. Then came the surveyor. I was rotating my herd to a fresh pasture when I spotted him, a man in a safety vest with surveying equipment, well inside my property line. I approached him on my ATV. "Can I help you?" I asked, trying to keep my tone neutral despite the trespassing. The surveyor, a young guy who looked fresh out of technical school, glanced at his tablet. "Just confirming property boundaries for Sagebrush Estates." "Are you Mr. Thorne?" "I am, and you're on private property, not Sagebrush Estates land." He frowned at his tablet. "According to these documents, this area is designated community space for the Sagebrush development. I'm just verifying the markers." I felt my blood pressure rising. "Show me those documents." He turned the tablet toward me. It showed a map of my property with about 30 acres, including my best grazing pasture and the creek that watered my cattle, highlighted and labeled. "Phase 3 Community Green Space." "This is incorrect," I said firmly. This land has been in my family for over a century. Your people have made a mistake. The surveyor shrugged. I just go where they tell me, sir. You'll have to take it up with management. And take it up I did. The next morning, I drove to the Sagebrush Estates clubhouse, a modern monstrosity of glass and stone that looked like it had been transplanted from aspen. The receptionist, a young woman named Olivia, recognized me immediately. Mr. Thorne! How can I help you? Her tone suggested she'd heard about me. I need to speak with Ms. Zimmerman about a surveying error. Do you have an appointment? Ms. Zimmerman is very busy with the new phase planning. No appointment. But she'll want to see me before I contact my lawyer about trespassing and fraudulent property claims. That got her attention. Within minutes, I was escorted to Brenda's office, a corner suite with views of both the mountains and, ironically, my ranch. She was on the phone but gestured for me to sit while she finished her call, which seemed to involve berating someone about improper mailbox decorations. When she hung up, her practiced smile appeared. Mr. Thorne, what seems to be the problem? I placed the county property records I'd brought on her desk. You had a surveyor on my land yesterday, claiming 30 acres of my property is part of your development. I want to clear this up now. Brenda barely glanced at the documents. Actually, Mr. Thorne, we've uncovered some interesting information during our due diligence. It appears that when the original development agreement was signed, there was a provision for community open space. The land in question was designated for that purpose. That's impossible. I never signed any development agreement. My family has owned this land continuously since 1892. She slid a folder across the desk. These documents suggest otherwise. When Milton Prescott initially planned the development, certain easements were established. We're simply enforcing pre-existing arrangements. I opened the folder to find what appeared to be a legitimate agreement with a signature that looked vaguely like mine, but wasn't. The document claimed I had agreed to designate the 30 acres as community property in exchange for infrastructure improvements that had never materialized. This signature is forged, I said, my voice deadly calm despite the rage building inside me. I never signed this. Brenda's expression hardened. That's a serious accusation, Mr. Thorne. Our legal team has verified the document's authenticity. If you continue making such claims, we may have to take action of our own. I'm not leaving my land, Ms. Zimmerman. Not 30 acres, not 1 acre. Then I'm afraid this will have to go through proper legal channels. In the meantime, we'll proceed with our development plans as scheduled. As I left her office, I noticed a framed photo on her wall. Brenda shaking hands with Milton Prescott at what looked like a groundbreaking ceremony. Something about their body language made me suspect there was more to this story than a simple property dispute. I drove straight to the county recorder's office, where my friend Lucy had worked for the past 15 years. If anyone could help me navigate the property records, it was her. Xavier Thorne, as I live and breathe, Lucy said when I walked in. What brings you to the dustiest office in the county? I explained the situation, and her usual cheerful expression turned serious. Let me pull the records, she said, disappearing into the archives. 30 minutes later, she returned with a stack of documents and a troubled look. Something's not right here, Zav. There's an addendum to your property deed filed 2 years ago, right when Sagebrush was getting started. But the filing protocol is incorrect, and the notary stamp is from a Nancy Lee who doesn't exist in our database. So it's a forgery. Looks that way. And not a very good one, if you know what to look for. But good enough to confuse things in a legal battle, which I'm guessing is what they're counting on. They probably figure you can't afford a protracted legal fight. She was right about that. The ranch was profitable, but barely. 3 years of drought had taken their toll, and my savings were designated for a new well system, not legal fees. What do you suggest? I asked. Lucy tapped her pen against the desk. First, get the original deed from your safe deposit box or wherever you keep it. Second, hire a lawyer who specializes in property disputes, not just a general practitioner. And third, she lowered her voice, Request all communication between the developer and the county through a FOIA request. If there's something fishy going on, that might smoke it out. I followed Lucy's advice and contacted Danielle Mitchell, a property rights attorney who had successfully fought several developers in neighboring counties. She wasn't cheap, but after reviewing my case, she agreed to a payment plan that wouldn't bankrupt me immediately. "This is a clear case of fraud," Danielle said after examining the documents. "The problem is proving it in a way that doesn't drain your resources before we get to court. These development companies have deep pockets and can afford to drag things out. So what do? We go on offense. We filed for an emergency injunction to stop any development on the disputed property, and we request a forensic examination of the documents they're using. But most importantly, we need to find out why they want that specific 30 acres. It was a good question. The disputed land wasn't particularly special, just good grazing pasture with a creek running through it. But as Danielle pointed out, in development, location is everything, and there had to be a reason they were targeting that particular section of my ranch. While Danielle prepared the legal counterattack, I decided to do some investigating of my own. I reached out to Milton Prescott, the original developer, who agreed to meet me for coffee at a diner halfway between his office in Denver and my ranch. Milton was in his 60s, with the weathered face of someone who'd spent plenty of time on construction sites. He seemed genuinely surprised when I explained the situation. "I never included any of your land in the development plans," he said firmly. "In fact, I specifically designed the community to complement the ranch setting. It was part of the appeal, authentic Colorado living next to a historic property." "Then where did these documents come from? They have your company's letterhead." Milton frowned. "May I see them?" I showed him copies of what Brenda had presented, and his frown deepened. "These are forgeries. Look at the logo. It's our old design from before the rebrand 5 years ago. We wouldn't have used this letterhead when these documents were supposedly created. And that's not my signature. Do you know why they would target this specific part of my property?" Milton hesitated. "I can't say for certain, but when we did the environmental surveys, there were indications of a substantial aquifer under that section of land. Water rights are gold in Colorado, especially with the drought conditions we've been seeing. If they control that land, they control the water." The pieces started falling into place. The creek that ran through that section of my property had remained flowing even during the worst of the drought. If there was an untapped aquifer beneath it, that would explain Sagebrush Estate's sudden interest in my unsightly ranch. Armed with this new information, I returned to Danielle's office. She immediately filed for the emergency injunction and added water rights theft to our countersuit. Then she dropped another bombshell on me. "I've been doing some digging into Brenda Zimmerman's background," she said. "Before she became the HOA president, she worked for Evergreen Properties as a community acquisition specialist. Care to guess what that means? She found ways to expand their developments by acquiring adjacent properties. Bingo. And she has a history of disputed acquisitions. 3 other communities where she worked had similar controversies, but they were all settled out of court with confidentiality agreements. I had to call in some favors with colleagues to get this information. So this is her playbook: forge documents, claim community rights, and either intimidate owners into selling or tie them up in legal battles until they can't afford to fight anymore." Danielle nodded. "Exactly. But she's never gone up against a property with as clear a title history as yours. That's why I think we can not only win but make an example of them." The judge granted our emergency injunction, halting any development on the disputed land and ordering Sagebrush Estates to cease all claims until the matter was resolved. But Brenda Zimmerman wasn't going down without a fight. 2 days after the injunction was granted, I received another certified letter, this time notifying me that Sagebrush Estates was filing a $2 million lawsuit against me for defamation, tortious interference with business relations, and malicious prosecution. It was a transparent intimidation tactic, but it still made my stomach sink. Even with Danielle's flexible payment terms, I couldn't afford a protracted legal battle on multiple fronts. That night, As I was checking on a pregnant heifer in the barn, I heard the sound of an engine on my access road. Grabbing my flashlight, I walked out to find a pickup truck idling near my property line. When I shined the light toward it, the truck sped off, but not before I caught the Sagebrush Estates maintenance logo on the door. The next morning, I discovered surveying stakes had been placed along the disputed property line, a direct violation of the injunction. I called Sheriff Parker, who came out to document the trespassing. "This is getting out of hand, Zav," he said as he photographed the stakes. "First forged documents, now this. These folks don't seem to respect the law much. Can you increase patrols past my place for a while?" I asked. "I'm worried they might try something more than just placing stakes. Consider it done. And for what it's worth, the whole department's on your side. Nobody likes seeing outsiders come in and try to bully a local family that's been here forever." That support meant more than he knew. As the legal battle intensified, I discovered just how much the community had my back. Neighbors volunteered to help with ranch work when I had to be in meetings with lawyers. Local businesses put up "Stand with Thorn Ranch" signs. The high school agriculture students even organized a fundraiser that collected enough to cover a month of legal fees. Meanwhile, Danielle was making progress. The forensic document examiner confirmed that both the development agreement and the deed addendum were forgeries. The notary stamp belonged to a Nancy Lee who had died 3 years before the documents were supposedly notarized. And most damning of all, the FOIA requests revealed emails between Brenda and Evergreen Properties discussing the acquisition of Thorn water rights through alternative means, after I had refused their direct purchase offer. But Brenda had one more card to play. A week before our court date, she approached me directly as I was leaving the feed store. "Mr. Thorn," she called out, her Range Rover blocking my truck in the parking lot. "I think we should talk man to man." I set down the bags of feed I was carrying. "I believe my attorney has made it clear that all communication should go through proper channels. This is off the record," she said, glancing around to make sure no one was listening. "I'm authorized to offer you $1.5 million for the disputed 30 acres. That's 5 times market value. You can upgrade your operation, modernize everything, and still have money left over." The offer was tempting. More money than I'd ever seen in my life. But I thought about my great-great-grandfather breaking ground on that wild frontier land, my grandfather teaching me to ride my first horse by that creek, and my father being buried on the hill overlooking that very pasture. "Ms. Zimmerman, that land isn't just dirt and grass to me. It's my family's legacy. And after what you've tried to pull, I wouldn't sell it to you for 10 times that amount." Her pleasant facade cracked. "Don't be a fool. You can't win against our legal team. Even if you manage to keep the land, we'll make sure your operation becomes unprofitable. We control the County Planning Commission now, and there are all sorts of regulations we can enforce." I pulled out my phone. "Do you mind repeating that? I think the district attorney would be very interested in hearing about your influence over county officials and your plans to abuse regulations for personal gain." Her face went pale. "You're recording this? That's illegal. Colorado's a one-party consent state, Ms. Zimmerman. I can record any conversation I'm part of. Now, unless you want to continue detailing your conspiracy on tape, I suggest you move your vehicle and let me get back to my ranch." She left in a fury of spinning tires and dust, but I had what I needed, an admission of corrupt intent that Danielle said was gold for our case. She immediately forwarded the recording to the district attorney's office, which opened an investigation into Brenda's dealings with county officials. The day of the court hearing arrived, and I wore my one good suit, inherited from my father and slightly too big in the shoulders. The courtroom was packed with locals who had come to show support, including Sheriff Parker, Lucy from the recorder's office, and even Milton Prescott, who had agreed to testify about the forged documents. Brenda sat at the plaintiff's table with 3 attorneys in suits that probably cost more than my monthly mortgage. She refused to make eye contact with me, instead staring straight ahead with the rigid posture of someone who still believed she could control the outcome through sheer force of will. Judge Eleanor Harris, A no-nonsense woman in her 60s who had grown up on a ranch herself, reviewed the evidence presented by both sides, then removed her glasses and looked directly at Brenda and her legal team. In my 30 years on the bench, I have rarely seen such a blatant attempt to defraud a landowner of their rightful property, she said. The documents presented by Sagebrush Estates are obvious forgeries, created with the intent to steal not just land but valuable water rights from a family that has held clear title for over a century. She turned to me. Mr. Thorne, your family's continuous ownership of this property is beyond dispute. I am granting your countersuit in full, including punitive damages against Sagebrush Estates and a permanent injunction preventing them from making any claims on your property now or in the future. The courtroom erupted in applause, which Judge Harris quickly silenced with her gavel. Furthermore, she continued, I am referring this matter to the District Attorney for criminal investigation into document fraud, perjury, and possible racketeering charges against all involved parties. Brenda's face had turned ashen. One of her attorneys leaned over to whisper something, but she pushed him away and stood up. Your Honor, there's been a misunderstanding. I was merely acting on information provided to me by others. I had no knowledge that any documents were falsified. Judge Harris was unmoved. Ms. Zimmerman, the evidence suggests otherwise, including your recorded attempt to intimidate Mr. Thorne and your admission of improper influence over county officials. Save your explanations for the criminal proceedings. As we left the courthouse, Danielle was jubilant. This is a complete victory, Xavier. Between the punitive damages and the legal fees they'll have to pay, you're looking at enough to modernize your entire operation and still have a nest egg left over. Sheriff Parker met us at the courthouse steps. Just thought you'd like to know, we executed a search warrant at Brenda Zimmerman's office this morning. Found quite a collection of forged documents relating to other properties they've been targeting. The DA's building a racketeering case as we speak. 2 weeks later, I watched from my front porch as FBI agents escorted Brenda Zimmerman and 2 Evergreen Properties executives from the Sagebrush Estates clubhouse in handcuffs. The investigation had uncovered a pattern of fraudulent land acquisitions spanning 3 states, with millions in illegally obtained properties. The new headlines read, HOA president and developers arrested in multi-state land fraud scheme. Brenda's perfect blonde bob didn't look quite so immaculate in her mugshot. As for Sagebrush Estates, the development was placed into receivership, while the legal mess was sorted out. The innocent homeowners who had purchased properties there formed their own HOA with a focus on being good neighbors rather than expanding their territory. With the settlement money, I was able to drill a new well system, upgrade my irrigation, and add a small processing facility that allowed me to sell grass-fed beef directly to consumers at a premium price. The Running T Ranch wasn't just surviving anymore, it was thriving. On the 1-year anniversary of the court victory, I hosted a community barbecue on the disputed 30 acres, complete with local beer, live music, and enough beef to feed half the county. Lucy from the recorder's office brought the original 1892 deed in a protective display case as a conversation piece, and Sheriff Parker grilled burgers while telling anyone who would listen about the time he put Brenda Zimmerman in handcuffs. As the sun set over the mountains, casting long shadows across the land my family had tended for 5 generations, I raised a toast to the crowd of friends and neighbors who had stood by me. To community, I said. The real kind, built on respect, honesty, and looking out for each other. Not the kind you can forge on paper or build with fancy clubhouses. The cheers echoed across the pasture, probably all the way to the federal detention center where Brenda Zimmerman was awaiting trial, contemplating how her attempt to steal my family's legacy had instead cost her everything. And as for the Running T Ranch, it would remain in Thorne hands for generations to come, the deed secure, the boundaries clear, and the legacy intact, not as community property, but as a reminder of what true community means.